You here. I want to begin by thanking the Chief Justice of the Lahore High Court, Justice Jawad Hassan, the Punjab Bar Council, the organisers of this event. I'm delighted former Attorney General Ashtar Saab is present here. And for me it's a great pleasure to be able to share with you some of my experience on a subject that is at the heart of what you do, namely advocacy. I've been a practitioner now, a barrister, QC for 13 years, a barrister for 15 years before that. And I've done hundreds of cases in the English courts, arbitrations all over the world, the ICJ case, recently for Pakistan, the Yadav case. And I'm also doing a case in Africa, in Kenya, in the High Court in Kenya. At all of that experience, I want to try and share with you in the next 20 minutes. Because as advocates, it doesn't matter which kind of court you appear in front of. In fact, each and every one of us during our life acts as an advocate in some way, shape or form. So if you're a parent, you're trying to persuade your children what to do and what not to do. If you're a friend, you're trying to do the same, and quite often friends don't listen. Maybe it's a question of style, maybe it's a question of technique. Sometimes the harder you try, the less easy it is to persuade. Gentle persuasion often works better than force. And there are some principles I want to share with you in terms of advocacy, because, alhamdulillah, in Pakistan there's no shortage of talent. On the bench, at the bar. I have been very fortunate, very privileged to have done work involving 60, 70 states, from Russia to the USA to Germany, having done work for India, Pakistan, Africa. And there is a common theme. Our job as advocates is to persuade. It's to persuade whoever's listening. It doesn't matter if it's 16 judges in the ICJ. It doesn't matter if it's a room full of people of this nature, or thousands of people. I've addressed thousands of people in the course of my career. I remember in China in 1998 having to address a room of 5,000 Chinese people, most of them wearing a military uniform. And it was a bit difficult to tell, one, whether or not they understood what I said, and two, whether or not they actually were taking on board and implementing. But this is 1998. Now there's a point that I want to make here, which is not on the subject, but a point that I emphasize again and again. Pakistan has enormous potential in all of you and in the entire population. In the 1990s, the Chinese didn't have a sophisticated commercial law system. When I was there in 1998 as part of the British government delegation, we were explaining to the Chinese commercial law, constitutional law, insurance law. 20 years later, we know where the Chinese economy is. It's the most powerful economy in the world. 20 years later, who are the major investors in developing states? It's the Chinese. What's the lesson? If they can do it, so can you. And that's the same so far as advocacy is concerned. Now, what I want to be able to share with you is the explanation as to what the role of an advocate is. And you have three responsibilities as an advocate. The first and foremost is to assist the court. When I act as an advocate before the English courts, and even anywhere in the world, I take my code of ethics with me. And the code of ethics requires me to act honestly, not to mislead, fairly, and to assist the court. We all operate in what's known as an adversarial system. You have somebody arguing against you, and you're trying to argue a point. The judge isn't supposed to be the third party in the argument. The judge is supposed to listen and decide. So the judge relies upon you very heavily, or the judges rely upon you very heavily, to present the facts, to present the law as clearly and as simply as possible. And whilst you have your duty to the court, you also have your duty to the client. The client is somebody who may have entrusted a hugely important matter to you. It may be a question of liberty. They may have been prosecuted for murder, they may be subject to a death sentence. It may be a huge business that has exposure of tens of billions. I've done commercial cases involving claims of tens of billions of dollars. For the client, this may be the one and only opportunity they have for somebody to listen to what they're saying and for their case to be presented. For you, there may be 2 or 3 cases in the day. You may be going in the criminal court, and you may have a roster of cases that you've got to deal with. But never forget, it's easy for me to say, but it's extremely important for you as lawyers. Each client deserves, and each client expects you to give them equal attention. It doesn't matter whether they're rich or poor. It doesn't matter whether they're big or small. It doesn't matter whether it's the state or somebody against the state. Each client deserves equal attention. Remember that. Because your duty is not just to the court, it's to uphold the rule of law. And what is the rule of law? The rule of law ensures that everybody is held accountable, that everybody is equal, that a society that is based upon rights and obligations doesn't favor one group to the disadvantage of others. Last night I was hosted at a dinner by some very bright, committed, idealistic young lawyers. I'm not going to mention any names. And I was very pleased to hear what they're doing. They're taking up causes of the most disadvantaged. And how do you test the health of a legal system? How well does it protect the most disadvantaged? The companies that I act for, the states that I act for, have ample resources. They can spend tens of millions, sometimes hundreds of millions on legal fees. But what about the orphan? What about the child that's been abused? The woman that's been harassed? The individual who's subject to oppressive use of force? Who's going to defend them? The answer is you are. And you mustn't hesitate to defend them in accordance with the law, because you are there to assist the judiciary to uphold the law. And in doing so, remember, you have ethical requirements to act honestly, to act fairly. A court is not a theatre. A court is not a boxing ring. A court is not a cricket pitch. I'm going to develop this further because ultimately, if you don't uphold these 3 elements, the duty to the court, the need to prevent your client's case effectively, fairly, act within the boundaries of ethics and etiquette, being polite, a legal system unravels. Next. Now these slides can be shared with you. It's very small print. Unless somebody's got far better eyesight than me, I'm not going to try reading them. So I'm just going to tell you what I believe you should do to assist the court effectively. First and foremost, your submissions should be succinct. Everyone know what I mean by succinct? Summarize. Very, very often, I was what's known as Treasury Counsel. I used to do a lot of work for the government. For 6 years, UK government. Judicial review, constitutional challenges. And lawyers are the same everywhere. If they have a bad case, they spin it out. They try and delay to get an adjournment. And they throw lots of material at you. Very often they're well paid. You're acting for the government, and you're acting on generally a very low rate. I would call it a charity rate. So I did my charity for 6 years with the government. And your job as the lawyer is to ensure that you provide the court with up-to-date case law. That if there's comparative material, you provide it to the court. The facts are presented in a summary way, clearly, crisply. Ideally, assist the court by providing the court with written submissions. In England, we produce what are known as skeleton arguments. Maximum 25 pages. I have just done a case where we had 90 bundles, this big. 90. My skeleton argument was 25 pages. Because that's the maximum limit for the court. Lawyers, the longer you give them, the more time they will take. And therefore, discipline yourself. Force yourself to say, I'm going to take as little time as possible. I remember when I did the provisional measures hearing in May 2017, I understand somebody in Pakistan said, well, he had an hour and he only took 20 minutes. Well, that's because I wasn't there to waste time. I was there to use time efficiently. If you want to persuade a court that you are right, you help the court focus on your arguments. And in terms of focusing on the arguments, don't waste time. Help the court. A person who wants to make a decision, who has to make a decision, needs to be assisted. And the more assistance you give the court, the more likely the court is to find what you're saying as being more helpful than the other person. And in terms of assistance, I don't know what the position is in Pakistan, but in Kenya I discovered that people can give authorities at the last minute, which I think is the same here. And in England, no. In England, you must serve your written argument 3 days before the hearing. You must produce agreed bundles of documents which have page references, which have an index, agreed. You can't go to court and say, by the way, I've just found this, by the way, I've just found this, and this. What's the reason? So that you're all looking at the same material, the judge is looking at the same material, and when you're producing a skeleton argument, you're giving a judge a route map on this material. Don't bombard your opponent or the court with documentation. There is one legal system which is also a common law system, and if anybody has studied in America, I'm not seeking to criticize the Americans, but because they're worried about professional indemnity claims, somebody suing them, American lawyers tend to throw everything at the judge or at the arbitrator. Every single argument they can think of. There's a long list. It's like, if you look at a written submission made by American lawyers, the index is more like an index to an encyclopedia. And how many of us like looking at encyclopedias? Well, if we want to find something in the encyclopedia, we're happy to do it. But to have to read through the entire encyclopedia just to find what's relevant doesn't really make sense, does it? So have enough confidence in yourselves to identify what the proper arguments are, as opposed to wasting time. How can you assist your client most effectively? First and foremost, by being seen to be an officer of the court. When I say an officer of the court, somebody who behaves with respect to the judges, who commands the respect of the judges. That's extremely important. We have the Chief Justice of the Law High Court here, Justice Jawad Hassan. We have the Attorney General, former Attorney General of Pakistan. The former Attorney General of Pakistan had to appear and has to appear before courts to represent the government in sensitive, difficult cases. And the advocate has to persuade the tribunal, doesn't matter which tribunal it is, Supreme Court, High Court, that the point of view that they're putting forward is the one that the tribunal should accept. If the tribunal doesn't respect you, that's unlikely to happen. And they're likely to respect you if they see you as somebody who plays fair, who doesn't ambush, who isn't hostile, doesn't try to bully their opponent, who doesn't exaggerate their case, who doesn't lie. No one likes liars, and I certainly don't like liars. I detest liars, but for me, I actually am happy to see a liar in one place. That is the witness box when I'm cross-examining them. That is where I'm very happy to see a liar. But other than that, if it's an opponent, and an opponent in England, I've not come across, in hundreds of cases, I've not come across a barrister who has lied in court. Ever. And that's fundamentally important. When you're speaking and you've finished, you have a right of reply here, I suspect. If you're the claimant, the defendant comes and then you come in at the end. The right of reply is actually extremely important because it's where you summarize your case, but you don't repeat it. Equally, when you're on your feet, use that time wisely. Don't waste your time. Check whether or not the judges have read what you've sent them, the written submissions. I know, I've heard about the enormous list that the judges of the Lahore High Court, Justice Jawad Hassan, prolific judicial industry in the sense of having to deal with numerous cases on a daily basis. In England, if I tell you in the commercial court, which has 12 judges, we only had 70 trials, 70. But one trial can take 6 weeks and can have millions of documents. And that from start to finish, from issuing a claim in the commercial court to getting a judgment doesn't take more than 2 years. That gives you an insight as to how quickly the process works in England. We can't get adjournments. I don't remember the last time I saw a client or an opponent obtain an adjournment. So if your client's asking you for delay, and if you're asking for delay because you happen to be double booked in 2 different courts, in England that's a disciplinary matter. A lawyer cannot be double booked. The lawyer can be the subject of misconduct